Good afternoon, everyone. Welcome to the panel event this afternoon entitled Racial Discrimination Against Nations and Peoples. We will be discussing the effects of the denial of the right to self-determination and its effects using some of the criteria or the principles developed from the 2001 World Conference Against Racism, the 2009 Durban Review Conference, and we will discuss also how it applies to the Common Covenants, the ICCPR, the International Covenant on Civil and Political Rights, and also the International Covenant on Economic, Social, and Cultural Rights, as well as ICERD, the International Covenant on the Elimination of Racial Discrimination. In particular, Article 15 of ICERD. So today I've been asked by the conference services, also by the Secretariat, that you're not allowed, unless you're with our group, but to be, unless we have authorized people to take pictures, not to take pictures. You can take some pictures for us. It's okay. It's okay. I give you permission, because when we have these side events, we do need to report. We have a very interesting panel, as Mr. Majid Trambu, Leon Siu from the Kingdom of Hawaii. Of course, Mr. Majid Trambu is very well known here. He's a permanent representative for IRM and an advocate for Kashmir. He attended the 2009 Durban Review Conference, and we worked together closely. We did a very intense lobby, and together we hosted, I believe, was one of the only self-determination panel events, because it was a very tight conference in 2009. So I will introduce, of course, Mr. Barrister Majid Trambu. He will do the first discussion.
Is it?
Yes.
I think I wanted to hear Leon first.
No, I want to hear you first.
Well, why don't we do this? Let's go ahead and start with Leon.
Yes.
And then we will...
After all, sir, you are the foreign minister.
Yes.
Well, I don't have any position.
Well, I want to defer to you.
Okay.
That's
Okay.
part of diplomacy, right?
So we will start with Mr. Leon Siu. He's a good friend for many years. Of course, Alaska and Hawaii have worked together many years, because General Assembly Resolution 1469, which removed Alaska and Hawaii from the list of non-self-governing territories. We both have our interpretations of this, so I'm just going to go ahead straight away and give the floor to His Excellency Leon Siu of the Kingdom of Hawaii.
Oh, mahalo. Aloha. Aloha ia mai o kou. A e maluhia hoi ke akua. E kou kako mākua. A e ka haku a me ka uhane hemolele. Greetings to all of you. It's good to be here. I just came in from the Hawaiian Islands about 2 days ago. And it's always a pleasure to be here in Geneva and to meet up with people of like mind and really people who are working so hard to for justice and for equality and for the right to self-determination. And so this is one of the areas in which, of course, we from Hawaii have been participating in for a number of years. We started sending delegates to the initial Indigenous conferences here in that started with the American Indian movement and a few others back in the 70s. And over the years, we've really developed some good friendships and good alliances, and have seen many of the wonderful people who've worked here over the years and become very familiar with many of the cases that are going on. So I am honored to be here today to speak about one of the foundations or the foundational principles about on self-determination, and particularly in the area of racial discrimination and xenophobia, etc. that were covered in the Durban conference and the Durban in the initial conference and the Durban Review. We started out talking about our situation in Hawaii as being an example of racial discrimination, of an area where the Hawaiian Islands were taken over by a foreign country, namely the United States, in the 1890s. And even though the Hawaiian Islands were already a sovereign independent state, there was a lot of racism involved in the motivation of, or actually let's say in the popularization of the effort to take over the Hawaiian Islands. So what really motivated them was, of course, economics and expanding United States power into the Pacific. At that time, the doctrine of manifest destiny was very strongly being proposed or being put forth in through the United States, and the press was really quite ablaze with this idea that the United States had this responsibility to spread and to become the world's leader in the areas of politics as well as in economics. And so the idea of expanding into the Pacific, where they already were, but now that what they felt was they needed a base that was closer to the Asian markets and to the Asian countries, closer so that they could expand their influence much more readily. So the Hawaiian Islands is in the middle of the Pacific Ocean, and it has an excellent harbor. And so the United States really coveted that harbor, and so they began a campaign, a pretty prolonged campaign from the 1880s until they were able to collude with some local insurrectionists in Hawaii to overthrow the Hawaiian Kingdom government. The Hawaiian Kingdom, by the way, was a fully recognized sovereign state, on par with the other sovereign states of the world, with treaties. And by the way, this year is the 175th anniversary of the official recognition of Hawaii as a sovereign state by France and Great Britain. So we are celebrating that this year, our 175th anniversary of being recognized as an official sovereign state. So in 1893, the United States had colluded with a group of insurgents in the Hawaiian Islands to overthrow the government, because the United States' objective was, of course, Pearl Harbor in the Hawaiian Islands to base their military expansion, or to use as a platform for their military expansion. And at the same time, the people in Hawaii, a few people, a handful of very influential, very powerful, and very wealthy people who had gained tremendous amount of wealth through the sugar industry, they decided that they wanted to stabilize the market for their sugar in the United States. So rather than being a foreign country to the United States with susceptible to tariffs and duties and things like that, they decided if they became a territory, if the Hawaiian Islands became a territory of the United States, all of those trade barriers would go down, and the sugar planters would be guaranteed a lucrative market to the United States marketplace. So that particular group, which consisted of about 13 men, and they were sugar barons and traders and lawyers, they decided that they would overthrow the government, and they colluded with the United States military and foreign minister, and they got this little plot together, and on a particular day, on January 16th, 1893, the United States landed its military force in the Hawaiian Islands. Now, this is a big surprise to the Queen and to the people of Hawaii, because there was no actual idea that there was any kind of animosity or any kind of conflict or hostility between the Hawaiian Islands and the United States. By the way, it also became a big surprise to the President of the United States when that happened, but I'll cover that later. So when they landed their troops, they did so in a paramilitary way. In other words, it was the military troops of the United States being landed with no authority to do so. But they landed, and they basically set up a bivouac in front of the Iolani Palace where the Queen was ensconced, and they basically lent their muscle to this group of insurgents that were intent on overthrowing the kingdom or deposing the Queen. So as a result, they were successful. The United States was successful in supporting this coup d'etat of the Queen. And then from then on, the United States failed, even though it admitted culpability and responsibility for the deposing of a friendly treated nation with whom there was no conflict or dispute. But anyway, they admitted that. However, they decided not to leave the Hawaiian Islands. So they have been there in the Hawaiian Islands since 1893, and which we have, and they started at that time to change the narrative about what actually happened, and were quite successful by actually creating a fake annexation of the islands in 1898, and then a provisional government for the Hawaiian Islands in 1900, and then had embarked at that time on a program to indoctrinate Hawaiians into believing that we were part of the United States. And so this indoctrination went on for 60 years, so 3 generations, and by the 3rd generation, the memory of the Hawaiian Kingdom being an independent state was actually erased. And by this time, by the way, the native Hawaiians had been also deprived of much of their lands and have been deprived of many of the civil rights that they had under the Hawaiian Kingdom. Not only that, our other residents, particularly the Asians, had also been deprived of the civil rights that were afforded them under the Hawaiian Kingdom. So the takeover was highly, it was affected by racial discrimination. And so this is an area where of course, we have been very sensitized to. In the 1970s, we finally began to unravel what had actually happened, that there had been an illegal overthrow of our government, there had been an illegal annexation of our country, and there had been there had been a series and a profound practice of racial discrimination in our islands. So this is why we started to reach out to the United Nations. And it's during that time that we also discovered the political illegalities of the United States in Hawaii. So in the recent years, we've actually come to understand our situation as that of an occupied territory, a sovereign country still, because that was never relinquished or was never extinguished. We're still a sovereign country, but now we're being occupied by an occupier that has been there for 125 years. So it's a difficult narrative to overcome because the world has come to consider Hawaii as part of the United States, because that was what the United States had put forth. So an action that started out of greed by both the United States and the sugar planters in Hawaii, which was also based on racial discrimination, and also was basically a takeover of a foreign country, a sovereign nation, in which the United States actually usurped our government and our position in the world, as that was what we came to understand, and it's what we are now functioning on. So our focus has shifted over the years from that of being simply, and I shouldn't say simply, but of that of being a racially motivated action by the United States to take over our country. But we also realized that it was also politically and economically motivated, and that we still today the Hawaiians, not only the native Hawaiians, but the Hawaiian nationals, the subjects and the descendants of the subjects of the Hawaiian Kingdom, have every right to restore our nation, to reinstitute our government, and to become reinstated as a sovereign state. So this is the condition right now is that Hawaii is a sovereign state under a foreign occupation, and that occupation, of course, does not comply to the laws of occupation, to the Geneva or the Hague Conventions. And so we are right now pressing for that to be rectified, and we are looking at various world courts, not just looking, we have cases already filed in various world courts, as well as we have some petitions with Alaska, with the human rights bodies here, as well as we're filing some petitions directly with the mechanisms at the General Assembly of the United Nations, namely the Committee of 24 and the Fourth Committee. So we are pursuing the reinstatement of our independence, and we're doing so with the focus on that Hawaii would be much better off in the future than having been subsumed into the United States and becoming an American territory. What we're looking at now is freedom from that and being able to express ourselves and participate, as well as to communicate to the rest of the world that we are a sovereign independent nation with a culture, a historical culture that is based on peace and is based on equality and based on all the principles that the United Nations actually has in the past has outlined as their principles. So we believe we will be an ideal country as a sovereign state, as well as our age-old values that come with the Hawaiian Kingdom, and that is the values of aloha and of treating one another with respect, with valuing our natural resources and taking care of things. We believe that as a sovereign country, we can become a model country. And so all we are looking for is to be able to govern ourselves and to remove the influences of the United States, particularly that of its military and its runaway corporate mechanisms that have been implanted into the Hawaiian Islands. So with that said, I just want to thank you again for inviting me, and mahalo.
Thank you, Leon, for your review on the illegal overthrow, the occupation, and also what we consider, because of the referendums 58, 59, Alaska, Hawaii, respectively, were not administered by the United Nations, but they were administered by the United States of America without effective monitoring. So we want to remove the stigma of 1469 so that we can continue to become recognized as independent peoples. The next person that on the panel is my good friend, and he's well known, Mr. Barrister Majid Trambu. As I said, he worked very well with us on the issue of Kashmir and self-determination. He worked side by side with us during the 2009 review conferences and is well aware of some of the issues and some of the provisions and what we need to do to overcome this quest for exercise of the right to self-determination.
Thank you, my very dear colleague, Ambassador Barnes, and thank you for inviting me to be on this panel. I'm very grateful, and thank you for your kind words. Having done that, I will focus myself essentially on the World Conference Against Racism. The 2001 conference and the 2009 review conference was essentially targeted for the eradication of all forms and manifestation of racism, racial discrimination, xenophobia, and related intolerance. Now, this gives an impression, to be quite honest, racism means, not essentially blacks and whites, but it was much wider than this, to be quite honest. And this definition includes colonialism, foreign occupation based on the doctrine of superiority, and for the full implementation of the International Convention on the Elimination of Racial Discrimination and the other treaty bodies such as the International Covenant on Civil and Political Rights. But it is overshadowed, unfortunately, and this fundamental principle of the World Conference Against Racism and the review, Durban Review, is somehow being hijacked on the basis of color, which is not necessarily the case. But yes, we got to address it in other areas of the problems that racism we see as exists around the globe. I now briefly want to take you to Dr. Alpha Desai's report when our former expert on international democratic and equitable order, which is very, very important, his report, which is submitted to the General Assembly. And the important part of the report is what we call now 69N, and the report reference is A64284. The full text, I want to read it for you because this is very crucial and very important. And I would want you to listen to it very carefully. That is what reflects what the World Conference Against Racism wished to see, and the 2009 Durban Review Conference wanted to see. Now, here is the actual quote. The General Assembly may consider revisiting the reality of self-determination in today's world and refer to the Special Committee on Decolonization and or other United Nations instances, communications by indigenous and unrepresented peoples wherever they reside. Now, this is very important. Indigenous and unrepresented peoples, and wherever they reside. Inter alia, Alaska, Australia, Canada, Chile, China, the Dakotas, French Polynesia, Hawaii, Kashmir, the Middle East, the Moluccas, the New Caledonia, North Africa, Sri Lanka, and West Papua, with reference to Chapter 11 of the Charter of the United Nations. And Chapter 11 is something which is very crucial for decolonization purposes. The General Assembly may also consider amending its rules and procedures to allow for the participation of indigenous and non-representative peoples. So there is a repeated reference to indigenous and non-representative peoples, which means people like Hawaii, people like indigenous movements in Australia and Canada, or unrepresented people such as from Kashmir. And it goes on to say, meanwhile, the Assembly should urge states to implement the Declaration on the Rights of Indigenous Peoples and Unrepresented Peoples. It should ensure that indigenous, non-representative peoples marginalized and disempowered peoples, and peoples under occupation have a genuine opportunity to participate in decision-making processes. And that is what is lacking at the moment. And that is where racism, the real racism, comes in. Whether, as our friend Leon highlighted the issue of Hawaii, and I, as a Kashmiri, highlight the issue of Kashmir. Now, what did actually the 2001 conference and 2009 review conference, Durban Review Conference, wanted to see? It actually has certain elements which are very crucial and which are very alarming, the review conference particularly. Now, first of all, it expressed the concern that challenges and obstacles identified in the declaration, that's the Durban Declaration, and program of action remain to be addressed. So we haven't fully followed the actual conference, 2001 conference, and then 2009 declaration. So we haven't been able to overcome those concerns in order to effectively prevent or combat or eradicate racism and the related intolerance. So what is needed? What the review conference said, we need to address with greater resolve and political will. And that's what is lacking around the world. The political will, at the end of the day, anything you want to achieve can only be achieved if there is a political will around the globe. And if that is missing, then it is more probable than not that you are unlikely to get the matters resolved. And this is why the Durban Review Conference emphasized to address with greater resolve and with greater political will to eradicate all forms and manifestations of racism, etc., and related intolerance. And that includes the occupations, that includes the indigenous peoples, and that includes the unrepresented peoples. And thirdly, it reaffirmed in a way that all peoples and individuals constitute one human family, rich in diversity, and that all human beings are born free and equal in dignity and rights. Now, the question still arises whether this is actually happening around the world. If this concern is that you should take the entire globe as one human family, then why do we have racial discrimination of any kind, whether it is color-based racism, or whether it is occupation-based racism, or whether it is indeed the colonial-based racism? So although we recognize it, although it is recognized by the Durban Review Conference and the original conference, but we haven't reached to that goal. So we need to have a political will to get to this goal, and therefore strongly reject any doctrine of racial superiority, whatever kind it is. It is, whether it is color-based or whether it is oppression-based or whether it is occupation-based. So we got to reject all of this. And we also have to condemn legislations, policies, and practices based on racism or racial discrimination or xenophobia and related intolerances. Now, here it comes to my mind a particular reference to the people of Jammu and Kashmir as a whole. Government of India, by using its judiciary, is trying to change a very basic constitutional guarantee that is given to the people of Kashmir. That is what we largely call Article 35A of the Indian Constitution, which is linked with Article 370 of the Indian Constitution. And Article 35A is that the demography of Jammu and Kashmir cannot be changed, which means that the outsiders who are not Kashmiris cannot buy or sell the properties and reside in the state of Jammu and Kashmir. That is the guarantees given by the Indian Constitution, which generated actually through the Kashmir legislation right in 1922, and which was official by an official notification issued in 1927. Now, Government of India has set up an NGO called We the Citizens, I think, sir. We the Citizens. Thank you very much, my Kashmiri brothers. We the Citizens, they have filed a petition in the Indian Supreme Court, which says that this is a bad law, and authority should be given to the Indian Parliament to change this law so that the demography of Kashmir is changed. If we look at the Durban Review Conference, it is illegal because it categorically says condemn legislations, policies and practices based on racism, racial discrimination, xenophobia and related intolerance, which are incompatible with democracy, transparency and accountable governance. This is the precise wording. So this is what needs to be stopped, and this is towards what this is one example. There could be hundreds of examples. All of you are sitting here. You may have your own stories to tell about the occupation or colonization or color-based racism. And when I say color-based racism, I don't mean white's priority or black's priority. I mean either of them, to be quite honest. So concern remains that World Conference on Racism, which is 2001, and Durban Review Conference, which my very dear friend brought to a notice that we worked very hard at the Durban Review Conference to bring on the agenda as part of the whole process of the conference the issue of right to self-determination. And the issue of right to self-determination is the part of the Durban Review Conference. It cannot go away. It cannot be ignored. It is very relevant to occupation. It is very relevant to suppression. It is very relevant to colonization. So, here we need to reaffirm the principle of equality and non-discrimination, which are fundamental principles of international human rights law. If we do not endorse and follow the Durban Review Conference, in my view, we are doing the biggest disservice to humanity. On a better note, we are not saying that the World Conference and the Review Conference has achieved nothing. No, at least there is basis to prevent racism around the world of any kind, in any manifestation. And states or member states of the United Nations are gradually Am I running out of time?
Maybe 2 more minutes.
Okay, 2 more minutes. Or gradually coming round to the situation that they have to address these issues. They have to address the concerns which the conference has highlighted in 2009. If you want a peaceful world, a better world, humanity-based world, then you have to get rid of racism in all forms and manifestation. Thank you very much, sir. I give floor back to you, sir.
Thank you, Majid, for your very well stated and put together argument based on the provisions of the Durban Review and the World Conference Against Racism of 2001, that we are to create political will and to deal with foreign occupation. And of course, when you look at the provisions, is also to address fully the ICER, the International Convention on the Elimination of Racial Discrimination, and also the Human Rights Treaty bodies. This is why we assert very well that the ICCPR and the ICESCR, Article 1 of the Common Covenants, are very essential to addressing the right to self-determination. Now, what I will do for you, because Alaska and Hawaii specifically sent petitions to, per Article 15 of the International Convention on the Elimination of Racial Discrimination. To start with, I'm going to point out there's an article entitled Alaska, How Did Alaska Achieve Historically Recognized International Status? It's in this current issue of Diva International that was come out last week. And in here are particular paragraphs that we highlighted. And this is the first paragraph I will read is a paragraph that the former independent expert on the promotion of a democratic and equitable international order, Mr. Alfred Morris Desaias, wrote in his memo concerning the case and the situation of Alaska. Here's the paragraph. The United States Supreme Court instituted doctrines of superiority and racial discrimination in law and policy by the Tehiton v. United States of America, making it clear in footnote 18, this is in the quote from the case itself, the purpose in acquisition and its effect on land held by the natives was distinguished from the settlement of the white race in the United States, where the dominant purpose of the whites in America was to occupy the land, unquote. What I found most astonishing is we have brought this case to him, to the Committee on the Elimination of Racial Discrimination. We brought this case also to the Human Rights Committee. We brought this to the former Commission on Human Rights. The one who recognized it fully was the former subcommission who offered a resolution in 1999. And what he says in the paragraph, further, the Tehiton judgment relies on the precedent of the Johnson v. McIntosh case of 1823, which held that the character and religion of the native inhabitants of America justified, and here's right out of the decision, considering them as a people over whom the superior genius of Europe might claim an ascendancy. So not only we have in the United States High Court 2 cases that have never been overturned, and I've said this many times, but finally, in 2018, he recognizes something very important. Read the last sentence carefully. I will read this for you. The denial of the right to self-determination on grounds of racial discrimination and the application of doctrines of superiority constitute a crime against humanity tantamount to a form of apartheid. So basically in his memo, he declared that there's apartheid in Alaska. Yes, this is before the end of his mandate. He signed this memo saying that he recognized there's apartheid in Alaska. These two cases still continue and have never been overturned. What I want to do is point out that in Article 73, there's one phrase, protection against abuses. Article 73B says that the states in administering territories are to work to protect against abuses the peoples of non-self-governing territories. This paragraph I'm reading from this article also says, at the San Francisco Conference in 1945, the United States delegate, under the leadership of Secretary of State Edward Riley Stettinius Jr., affirmed to the Netherlands delegate that, quote, protection against abuses, unquote, in Article 73 of the UN Charter includes the obligation to protect against racial superiority. So what we have, a direct reference when they were developing the paragraph in 1945, is a question from the diplomat to the delegation headed by the Secretary of State, and we can argue that under the unilateral declaration principle from the 1933 Norway v. Denmark case that established clearly that when it comes from the Secretary of State higher, it is just like an act of state, meaning it's an act that becomes law. So this is why when we brought our case to the Committee on the Elimination of Racial Discrimination for CERD, we brought a petition. What I want to explain is under Article 15 of ICERD, the title of this is the Article 15.1, pending the achievement of the objectives of the Declaration on the Granting of Independence to Colonial Countries and Peoples contained in General Assembly Resolution 1514 of 14 December 1960, the provisions of this convention shall in no way limit the right of petition granted to these peoples by other international instruments or by the United Nations and its specialized agencies. This is important because when you look at the special procedure, and this is the important thing that I'm bringing out because we brought we raised the issue of our petition to the treaty bodies, and of course, vitally important, we brought this to the follow-up of the Durban Review Conference, and also to the Ad hoc Committee on Complementary Standards to show that either there is a gap that allows peoples of non-self-governing territories, especially since the Declaration on Friendly Relations of 1970 states that if a peoples have not effectively exercised or consented in the exercise of the right to self-determination to the diminution of their independence or their sovereignty, the situation or their status persists. Meaning that because not only did they apply racial discrimination, which Namibia, South Africa, Rhodesia, now Zimbabwe, clearly established in international law, that the denial of the right to self-determination on grounds of racial discrimination is a crime against humanity. And we bring up the fact that if it's a crime against humanity, there are no statute of limitations. And of course, in the report of Alfred de Zayas, he stated clearly, there is no lapse of time for these violations. So when we bring this specifically to the complementary standards, who is to implement fully and to promote ICERD and also the ICCPR from the Human Rights Committee, that this should be implemented. Now, when we brought our cases to the Human Rights Committee in the same article, it states it had a special paragraph for them to address the illegal overthrow of the Hawaiian Kingdom, and the committee said to address the permanent trusteeship of Alaska. So we have these very well established calls by not only the Human Rights Committee, but also the issue was brought up in ICERD at the Committee on the Elimination of Racial Discrimination. And what the members of the committee said when one member brought it up is we need another international body as stated in the convention, and I will read you two. This is important because what was stated by the Anti-Discrimination Unit, that when the follow-up of the Durban Review Conference tried to get a comment on hate speech, the CIRD committee said that it is not in our mandate for CIRD to be making this. You just have to refer to the general comments. So this was one of the reasons that they said that we cannot raise the question, except when you look at Article 15, it states clearly that they can receive petitions, and they not only have the procedure, they develop a special procedure. And what I will read out for you is the content of this special procedure that was developed by the Committee on the Elimination of Racial Discrimination in 1970. And in my paper that I presented especially, it says since the Committee on the Elimination of Racial Discrimination can invoke paragraph 5 of its 1970 procedure, it adopted during the second session concerning Article 15 of the ICERD. And here's what it says. It has this paragraph 5, the committee notes, however, that Article 15 of the Convention does not empower to receive any petitions directly or through any channel other than the bodies mentioned in subparagraph 2A, referring to Article 15 of that article. It is decided to defer it to its second session consideration of the procedure it will follow if a petition is addressed to it directly or through other than the appropriate channels, meaning not receiving it from a specialized agency or body of the United Nations, with a view to adhering strictly to its terms of reference on the one hand, while on the other hand, not depriving the petitioner or the competent bodies of the United Nations of the opportunity to have such a petition considered by an appropriate international body. What happened is the committee deliberated. And there were those who disagreed, said, we need to accept this petition, not deal with it. It is pursuant to Article 15 to transmit it to the appropriate body, i.e. the Third Committee of the General Assembly, who can transmit it to the UN Decolonization Committee of 24, now referred to as the Special Committee on Decolonization, to get their views with a view to returning it back to us, to give us instruction on how to treat this issue. Because we brought up the very issue of discrimination and the denial of the right to self-determination on grounds of racial discrimination, the doctrines of superiority, and CIRD refused to deal with it. And what we, in some of our lobby maybe, we said that there's a bit of politicization and selectivity here. They came up with many or various excuses as to why they could not. So what we did is we brought it to the Ad Hoc Committee on Complementary Standards to see if there's a gap in ICERD in order for us to address this, that perhaps they can request per 69N, which my distinguished colleague brought up, which was recommended by a special procedure of the United Nations. And with this, they can accept the petition, including those under 69N, the recommendation, and transmit this back to the United Nations Committee on Decolonization, since the violations of both Alaska and Hawaii and others are so grave that they constitute a crime against humanity. As we said many times, the denial of the right to self-determination on grounds of racial discrimination is a crime against humanity. So, what I gave you was an essential element of the very reason why we brought to the week before the working group on the to implement the World Conference Against Racism. So we have two paragraphs, and I want, before I close, I want to expressly read this paragraph. And we drew and we quoted specific provisions of the World Conference Against Racism, and some of them, as Mr. Majid Trambu read, and we presented this paragraph. Reaffirms the commitment to address the scourges of racial discrimination and doctrines of superiority and colonialism and foreign occupation of peoples and nations, allowing for their full participation with a view to transmitting the conclusion and recommendations to the appropriate bodies of the United Nations. This was submitted by myself as an NGO, the Indigenous Peoples and Nations Coalition, supported by other NGOs who attended the World Conference Against Racism. So that you more clearly understand what I'm talking about, to follow in the conclusion, we also presented this recommendation as a follow-up. Recommends that CERD accept petitions and proposals under Article 15 of the ICERD from all peoples, with particular reference to a recommendation of paragraph 69N of A/68/284, with a view to transmit petitions to the appropriate body of the United Nations for review. If essentially a recommendation comes from these ad hoc committees or bodies, goes to the council, they make the recommendation, CERD will have to review this and transmit our petitions to the appropriate body. There will be no more excuse. With that, I believe I explained, so I would like to open the floor for questions.
3 minutes.
We only have 3 minutes. Do we have some questions? Okay, we have, state your name. Question, we only have 3 minutes.
Just I would like to give a declaration and information about the new case of decolonization in the International Court of Justice. A new case will come on the citizenship problem of Myanmar, because the problem of Myanmar solution for the statelessness of 17 million people is based on decolonization. And the first responsibility is for United Kingdom, if not for the Human Rights Council. This is important because it's the follow-up mechanism for the first time to take a case to the Human Rights Council on the decolonization process, which will be directly affect to Kashmir problem and Alaska. And I would like to ask a question to Mr. Trambo. So the first responsibility is to the United Kingdom to take the case to the International Court of Justice on decolonization. If just in case they do not want to do it in the real politics of whatever, can we, with your help, open a court to the United Kingdom, because we are a United Kingdom citizen, and then you are forced, as a responsibility of all these issues, to take the case to the International Court of Justice. And on the 19th of next week, I will explain detailed about this system on the citizenship of Myanmar. A person from Myanmar government will come as well to support.
Well, very briefly, I got one paragraph here from Diva, which is written on the article on Alaska. The 1970 General Assembly Declaration on Friendly Relations, adopted by consent, states that the status of territory or colony remains separate and distinct until the peoples have exercised their right of self-determination in accordance with the purpose and principles of the Charter. Now, that being the position, Professor Nazir Ahmad Shah, who is sitting here, declared, I think at a Brussels conference, at a Brussels news conference, that a legal team in United Kingdom has been set up by Diaspora Kashmir to look into the possibility of taking the United Kingdom to the court in relation both to the occupation and the Article 35A and Article 370, which I brought to your notes earlier. So that is the position as it stands.
Say just very important, because this is an international agreement of United Kingdom, no Atli, and in Article 14, if there's a disagreement, the case is taken to the International Court of Justice.